Neville Cooley, an architect with experience in the gas sector, was Managing Director of Industrial Development Consultants, a company supplying services to clients including the British government's gas boards. The company had negotiated with the Eastern Gas Board for the design and construction of new gas depots, but the negotiations were unsuccessful and the gas board abandoned its intention to build the depots. Sometime later, a representative of the Eastern Gas Board met privately with Mr. Cooley and indicated that they may still build the depots and that he personally might obtain the work if he was no longer a Director of Industrial Development Consultants. Cooley did not tell his colleagues at Industrial Developments that the Gas Board was again considering the depots. He did not tell them the Gas Board had offered the work to him. Instead, he falsely told them he had a health issue, resigned as Managing Director, formed a new consultancy and obtained the work with the Gas Board. Industrial Development Consultants sued, arguing that Cooley had breached his fiduciary duties to the company. The court agreed. Justice Roskill said, "Information which came to Cooley while he was Managing Director and which was of concern to the plaintiffs and was relevant for the plaintiffs to know, was information which it was his duty to pass on to the plaintiffs, because between himself and the plaintiffs a fiduciary relationship existed. He embarked upon a deliberate policy and course of conduct which put his personal interest as a potential contracting party with the Eastern Gas Board in direct conflict with his pre-existing and continuing duty as Managing Director of the plaintiffs. That is something which for over 200 years the courts have forbidden. The duty applied even though the company, Industrial Developments Consultants, had tried and failed to obtain the work." Reading the case, one gets the strong sense that the two key factors were, first, that the information which Cooley obtained privately could have been helpful to the board because they could have tried again to get the contract with the Eastern Gas Board, and second, the court took a dim view of Cooley lying his way out of his contract. From this case, we learn that a fiduciary cannot place themselves in a position of conflict of interest, even if the company, the beneficiary, would have been unable to obtain the profit themselves.